forms of property, government property, that are not generally open to the public for free expression activities. And in talking about non-public forums, the government has a greater opportunity to control both the content of speech in those forums, or is it fora, I don't know, and the time, place, and manner of speech in those places. First, as to content, the government can limit speech in a non-public forum to subjects for which the property is dedicated. So, for example, government offices can be dedicated to the work done in the office. You can't necessarily have your anti-government parade in the office. Public school teacher mailboxes can be dedicated to the receipt of official school information. And even if the government does permit some limited free speech activities in a non-public forum, it can permit some subjects and not allow others. But it has to be what the court has described as viewpoint neutral. To illustrate this, take the case of Cornelius versus NAACP Legal Defense Fund. There, the government opened up its workplaces to certain charitable solicitations. It didn't have to. It could reserve the workplaces to work stuff, but it opened it up to charitable solicitations. But it said you could only allow charities that provide direct aid as opposed to those kinds of charitable organizations that are really advocacy groups. Because the government didn't want workplaces to become places of controversy engendered by which advocacy group will be supported or not. So it thought it could draw this line between groups that were direct givers and groups that were advocacy groups. The court said if that was the way that they were drawing the line, that was okay, because that was opening it up to certain categories, but it was viewpoint neutral. On the other hand, if what the government had done was opened it up to some degree, allow charitable solicitations, but identify only certain charities that could solicit and restrict others because of their viewpoints, that would be unacceptable. But you can control content. Viewpoint is a subset of content. And if you allow certain categories in, even though you don't have to, you can't viewpoint discriminate within those categories. Now, what are these non-public fora or forums aside from government workplaces where people can literally be kept out completely? As I said, military bases, jails, schools, government airports, government telephone poles. You know, you just can't put up any old sign you want. They can be limited to official signs or no signs at all. Special service kinds of sidewalks associated or connected to postal service property, teacher mailboxes, all of those kinds of things. Now, another specialized area is regulation of the electronic media, radio and TV. Now, this is a whole course in itself, but I just want you to understand that the court has said that because this media is limited spectrum, although that's obviously changing, and it has this special power to intrude into our homes, the government has greater latitude to regulate. For example, it can regulate even non-obscene, simply sexually explicit material, and it has, the court has upheld requirements that the electronic media give rights of reply to candidates who are criticized in their editorials, even though they couldn't have the same right of reply for newspapers. That's because there's a far greater latitude to regulate this kind of media. The government also has a far greater latitude to regulate the speech of government employees, particularly on the job. Now, it's not an anything-goes business. Government can't, just basically shut up government employees. And if we're talking about government employees after they leave the job, there are some opportunities to regulate. You can tell the government employees they can't disclose government secrets, for example. You can tell government employees that under the Hatch Act for federal employees, for example, they're limited in their political activities. And even on the job, or especially on the job, you can control speech to a greater degree. You can't just do anything. You can't fire an employee just for talking about matters of public concern, but you can regulate government employees' speech. You can say that when they're at work, they should be doing their work, for example. And you can even punish them for speech on the job, even if it involves a matter of public concern, if officials can show that somehow that speech impaired the efficient performance of your work, or undermined authority in the office, or destroyed close working relationships, or something like that. So, again, far greater latitude to regulate government employees' speech. And finally, there's far greater latitude to regulate the speech of students in schools. Now, we're pretty fond of saying, that students don't leave their First Amendment rights at the schoolhouse gate. But, in fact, students don't have full First Amendment rights in school, and they don't have the same rights that adults have out on the street. First of all, schools are supervising children. We're dealing with minors, so there's always greater latitude to regulate. And second, here's something. Schools are obligated to control content. It's called curriculum. And so we have special rules for students in schools. First of all, schools can prescribe course content. It can establish the curriculum. And curriculum includes controlling what goes into a school newspaper if it's part of a course in journalism. So the government can prescribe what articles appear in that course-based newspaper. As long as there's a reasonable pedagogical basis for the school's decision, their control of content in this regard doesn't violate the First Amendment. Schools can also set standards for decency and discourse among students, and therefore a school was upheld when it disciplined a student who, for example, gave a lewd speech in the auditorium. Actually, the court included as an appendix the particular speech in that case. In a non-curricular setting, such as in the lunchroom, say, or in the hallways or at your lockers, a school can also prohibit or punish speech that materially disrupts school activities. But this would have to be established. So remember the Tinker case where the students were wearing the black armbands. If the government wanted to get at their particular content, opposition to the war in Vietnam, even though they were in school, there had to be some showing that their expression would result in disruption in school activities. They couldn't just regulate it for any reason or no reason. So, looking at the First Amendment overall, with our sort of journey through this now, what you need to do if you have a free speech problem is try to sort out what kind of problem it is that you actually have. At the outset, see first of all if you're dealing with any of the special contexts I've just mentioned, because then you'll want to orient yourself within those contexts. But more generally, if you're talking about standard kinds of government regulations of speech, see if you have content control or time, place, and manner control. And if you have content control, does the speech nevertheless fall into one of these categories that has its own special rules? If it does, apply the rules of the category and see if they actually apply. Otherwise, if you have content control in a public forum, not in a specialized context, and it's not within one of the categories, you apply this exacting, compelling justification test. On the other hand, if you have time, place, and manner controls, that's an important test, but obviously it's less stringent. Are there significant government interests that are furthered by the government's regulation, narrowly tailored and not overbroad, leaving open ample alternative opportunities for communication, in which case the time, place, and manner regulation will be upheld. Also, consider whether your particular problem involves any potential argument that the statute or the rule at issue is either vague or overbroad or involves a prior restraint. In other words, here, I think it's a good idea to make yourself some checklists or a roadmap, and then, if you have those in the back of your mind, you'll be able to sort out any particular free speech problem and respond to it appropriately when you see it. Okay, in the final minutes of our final tape, we're going to talk about the religion clauses. There are two religion clauses in the First Amendment. One prohibits the establishment of religion by the government, and the other protects the free exercise of religion by individuals. There's a certain tension between these two clauses sometimes, and no precise test really is available to perfectly let us figure out how to accommodate them. It's kind of a balancing of interests depending upon the context. Take as one example to illustrate this tension and how we try to resolve it. We do treat differently the government paying for religious figures, priests or chaplains or whatever, if they're at work in the military. We treat that differently than we do chaplains or priests or what have you going in and saying prayers in the elementary public schools.